All right. Good afternoon. Today, gonna take a look at the last couple of developments in the DeCastro versus Abrams et al. Lawsuit. So it most certainly was you. It's always you. But it's good to see you. So, like I've said previously, I find Delete Lawz to be a fundamentally uninteresting person in general. So I don't cover his videos. I watch other people cover him because to me that's what's interesting. I like laughing with Irish Demon or with Masshole or Team Skeptic, But as a lawyer, I do find lawsuits interesting. Good to see you, Empty Woods. So, but I'm not going to breathlessly rush out and cover every single development because it's unnecessary. So, last week they filed competing motions for contempt. His had no shot. Kate's had a very slight shot. They were both denied. That's all that needs to be said. The judge reminded them, "You're not in kindergarten. Act like it." So where I'm going to start is the defendant's joint motion. I like this. I like that Josh and Kate filed a joint motion instead of each filing their own. Well, you're welcome to lurk or not. Join in. I'm glad to have you here anyways, Causeless Rebel. But so joint motion to extend time to file a response to the first amended complaint. So Merb covered this the day it was filed a couple days ago. And so generally, Merb can be a dick. His legal analysis is generally very good. So I have no qualms about his analysis of this motion. I had a different opinion than him, though, which I'll get to as I go through. So the motion, short and sweet, pursuant to Rule Civil Procedure 6B, the defendants jointly move that the Honorable Court extend the time to file responses to plaintiff's first amended complaint, ECF number 62. As grounds for the motion, plaintiff has indicated that it will file a second amended complaint in this action. See email requesting assent to amend complaint, attached herewith as Exhibit A. So pursuant to Local Rule 15.1 sub B, this requires plaintiff to serve a copy of the motion to amend with the proposed amendment on the new party 14 days prior to filing the motion to amend with the court. Accordingly, the defendants jointly request that the time to file a response to the first amended complaint be extended to 21 days after the second amended complaint is properly filed or plaintiff gives notice that he no longer wishes to file a second amended complaint. Boom. That's the whole motion. So I assume Cheeky Monkey by other lawsuit, you mean the Ironton lawsuit? I mean, that one was dead on arrival anyway. It's a waste of time and money. I mean, he's not spending any money, but it's even he has better uses of his time than frivolously suing a sheriff. Well, police chief. Morning, Allie. And afternoon, Sean. So then this is the exhibit that Joshua Garrick filed in support. Mr. Wish and Mr. Garrick, even though it, as Merb brilliantly pointed out, it was emailed to Brian Wilson instead of Benjamin Wish. Would you be opposed I add TuTube and YouTube personnel to the copyright lawsuit? Regards, Jose DeCastro. So Merb was of the opinion that this may have been premature, asking for extra time, and he thought it was kind of a toss-up whether Judge Burroughs would grant the extra time. His analysis was fine. I had no issue with it. But you know, this is what lawyers do. We argue what we think, or we argue on our client's behalf, even if we don't believe it ourselves. I thought this had a really good chance of being granted because, number one, the court had just last week, 2 weeks ago, granted Delete Lawz 21 extra days to file his answer to the cross complaint, to their counterclaims. And his whole argument for that was, well, I really don't understand the rules. And so I thought, even though you had already denied my motion to dismiss, he thought that press pause, it told the time, the 21 days he had to respond with an answer. So that's a completely, just absolute misunderstanding of the rules. And frankly, it's inexcusable, but the judge granted him extra time. So when Josh and Kate come asking for extra time based on what Delete Lawz has told them is going to happen, he has said, my whole goal, I don't care if I win, I want to cost you legal fees. That's on video. They've provided that quote to the judge. It was the heading of the contempt motion. And the judge isn't blind. He sued them for defamation, and then his first amended complaint changed to copyright and no mention of defamation. So the judge can see, well, if he's going to file a second amended complaint, which isn't a right, by the way, you have to ask for permission. You have a right to a first amended complaint. You have to ask for permission to subsequent amendments. But the judge can see the second amended complaint, the defendants might be defending completely different claims yet again. And so it just makes sense that she would grant extra time so that they only have to file one answer. So I had a feeling that it was going to be granted, which, spoiler alert, it was. So moving on, for the main event, yesterday, Delete Lawz filed the motion for leave to supplement first amended complaint, which this has me convinced he must be the dumbest quarter of a man alive. I mean, in a world that includes Kanye West and various others, he can't be the dumbest person alive. But I do think he's the dumbest quarter of a man alive. So, pursuant to Federal Rule of Civil Procedure 15 sub D, plaintiff Jose DeCastro, plaintiff or I, that don't do that. It's never I, it's plaintiff or DeCastro. I realize that's a minor quibble, but it really makes things easier to read. Respectfully moves this honorable court, for which he's, accused of corruption, honorable court, for leave to file plaintiff's supplemental complaint. See attachment 1, supplemental complaint. I provided the proposed supplemental complaint to counsel for defendants and conferred via email. Defendants do not oppose adding YouTube as a defendant, but they will require more time to answer the First Amendment complaint, which I have not yet stipulated to. They didn't stipulate to you having extra time to answer their cross complaint, their counterclaims, and your stipulation is irrelevant. The judge has granted it. I mean, he did file this before it was granted, but and of course, Kate and Josh do not oppose to adding YouTube as a defendant, because this is the dumbest thing that Delete Lawz has done yet. So the argument: courts may permit supplemental pleadings setting out any transaction, occurrence, or event that happened after the date of the pleading to be supplemented. Federal Rule of Civil Procedure 15 sub D. The First Circuit has recognized that courts customarily have treated requests to supplement under Rule 15D liberally. U.S. ex rel. Gadbois versus Pharmerica Corp. I have a feeling this was one of his ghostwritten motions, just based on the way that quote was integrated and cited. It's different stylistically than the ones that he obviously writes in his hopped up state, shall we say. At least I'm convinced he's hopped up writing it. This liberality is reminiscent of the way in which courts have treated requests to amend under Rule 15A's leave freely given standard. Id. See also Keith v. Volk, which says Rule 15D is intended to give district courts broad discretion in allowing supplemental pleadings as a tool of judicial economy and convenience, and its use is therefore favored. He has a fundamental misunderstanding of what copyright laws are. I mean, of course, he's got a dimwit legal advisor in discussing laws, Dr. Law, who somehow thinks this is going to be a landmark, groundbreaking fair use case, because courts just haven't decided it yet, even though there's thousands of court decisions on fair use. And but he especially doesn't understand the DMCA, Digital Millennium Copyright Act, or as Delete Lawz puts it, the Defense Contract Management Agency, I think, or just everything they discuss is wrong. So, but we'll get to that. So here, plaintiff filed his first amended complaint on November 16th, 2022, document 62 in the record. After using the first amended complaint for some counter notifications under the DMCA, Digital Millennium Copyright Act. He's so dumb. YouTube revealed their behavior that broke their safe harbor protections under the DMCA. He is so dumb. I mean, we'll discuss it. And also made decisions to leave content infringing on plaintiff's copyright on the YouTube platform, making YouTube partially liable for any further damages after their processing of the DMCA notice. Plaintiff could not have known that YouTube would have behaved in this tortious manner until after his first amended complaint. I have also published content since the date of the first amended complaint that has been infringed. No factors exist that would support denial of plaintiff's motion. Okay. I mean, the defendants stipulating to it kind of allows it, so, because they're not dumb. They see that you bringing YouTube into this is going to backfire colossally. That's it. He has no idea what fair use is. He has no idea what the DMCA is. And that's it. He makes claims but offers no facts. Everything he does is conclusory. He states his conclusion, not how he got there. So listing see Pharmerica Corp at 7, listing some factors a court may consider in denying a motion to supplement. What factors are those? Tell us what those factors are. Plaintiffs have not unreasonably delayed attempting to supplement. This motion comes less than 2 weeks after the facts arose, with a holiday during that time. The supplemental pleading will not unduly prejudice the defendants and will help preventing them having to countersue for several liability of YouTube. What? Well, what is that? It will help prevent defendants having to countersue. Countersue who? Countersue you again? Countersue YouTube for several liability of YouTube? I don't know what he's trying to get at with that sentence, but no responsive pleadings have yet been filed. Yeah. And they asked not to file responsive pleadings until after you file your latest lawsuit attempt. And all parties were on notice of this potential supplementation through conferring over email. Plaintiff's supplemental claim is not futile. It is. Plaintiffs have pleaded allegations which, if taken as true, as they must be at this stage, state a claim for which the court can grant relief. So remember, last video we discussed Rule 8 pleadings and the Iqbal Twombly standard, and also Rule 12b-6, the motion to dismiss for failure to state a claim upon which relief can be granted. So he must have watched either my or Merb's video discussing Rule 8 pleading, because yes, the standard is you file a complaint, the court doesn't analyze whether what you've stated is true or not. It takes it as true for the motion to dismiss. They say, if what you have pled is true, could we grant you relief? And the answer here is no. At least as to YouTube, because they take the facts to be true. They treat the facts as if they're true. His misstatements of the law, the court will never accept as true. They will never accept misstatements of the law as true. They will take one look at his misstatements of the law and say, there's no claim here. We can't grant relief based on your misinterpretation of the law. It's asinine. So, C. Hatch versus Department for Children, Youth, and Their Families. An amendment is not deemed futile as long as the proposed amended complaint sets forth a general scenario which, if proven true, would entitle plaintiff to relief against the defendant on some cognizable theory. That's it. Some cognizable theory. There is no legal theory here. There's a legal misunderstanding of the law. Just a fundamental misunderstanding. The court does not have to accept your interpretation of the law. On a motion to dismiss, they have to accept your facts. They don't have to accept your law. So basically, under Rule 8 standards, he has not pled a cause of action here that he can have relief granted. Good to see you on clean hands. So it's going to be dismissed. So conclusion of the motion. Since supplementation will aid in the speedy and effective resolution of this case, yeah, YouTube's going to 12b-6 in about 3 minutes. I respectfully request this court grant my motion for leave to file my supplemental complaint. The problem, Asta, is this isn't even a half-truth. This is his, basically, he's cosplaying that this is fan fiction of what copyright laws are. It's so far off from what the law is that I can't even, like, for lawyers, when analyzing laws, you start at A and work your way over to B. I can forgive starting at A and going a loop-de-loop pattern to get to B, but he hasn't even ended up at B. He's taken a straight line to about triple Z. I don't understand how he gets here. And that's it on clean law hands. I mean, I can't say if I've seen your video covering him or not, because as you've said, you've had one video covering him, and that was a long time ago. But based on the standard of your videos, it's obviously fair use. I mean, every video I've seen of yours, I'd classify as fair use. Some are more fair use than others, but they've all been fair use as far as I've been able to tell. I don't actually know if he has attempted or not, Cheeky Monkey, because we're getting now to his supplemental complaint, which he had to file as an exhibit attached to that motion. So this should be funny. And that's it, Asta. He's working at getting kicked off the internet. That's why this is about the stupidest thing he can do. So, supplemental complaint. Pursuant to Federal Rule of Civil Procedure 15D, plaintiff Jose DeCastro. Plaintiff. He doesn't put I on here. That's a good development. Let's see if he follows it. Hereby files this supplemental complaint to its first amended complaint in connection with its federal claim of copyright infringement, adding YouTube, Google LLC. I mean, for starters, is Google actually an LLC? I don't actually know. Alphabet is clearly a corporation. That's the parent company. It very well could be that Google and YouTube and other subsidiaries are organized as LLCs, limited liability companies, because you don't necessarily have to organize your subsidiaries as corporations, since they're all consumed into a corporation. But once again, is YouTube actually like a subsidiary of Google, or is Google even actually involved? Because I'd have to look at the corporate flowchart. I have a feeling YouTube is actually owned by Alphabet. And yes, people say, Daddy Google, because colloquially, I can't speak, we do refer to Alphabet as Google, but it is technically different. So I think referring to YouTube as Google LLC is probably wrong anyway. And that's it. He lets us all know what he's going to do. He makes it easy. And Google wasn't bought. It all happened a while ago. I mean, they changed the parent company overall name to Alphabet, and then kept sort of the Google division, which they very well could have started an LLC and transferred that portion of the business into it. I'm just guessing. And often what happens, Causeless Rebel, is a company will start as an LLC, and then in order to go public or in order to start raising private funds from angel investors or venture capitalists, they'll incorporate as a corporation and switch from an LLC to a corporation. This is all irrelevant for now, but I'm just quibbling about Google LLC in here. So, and it's unidentified employees making copyright determination. John Doe's 1 through 20 as defendants. Jesus Christ, this is dumb. But no, Alphabet is the umbrella corporation. Google is just a division of Alphabet now. Alphabet is the same company as what Google was before rebranding as Alphabet. Further, plaintiff supplements facts in copyrighted works and alleges as follows. So now, this is exceptionally dumb. So he's bringing in YouTube and its unidentified employees making copyright determinations. Google's employees, YouTube's employees, bear no liability here whatsoever. I mean, just as you look at his Ironton lawsuits and how Pam Wagner, the chief of police, has qualified immunity as a state employee, as a state actor. In this situation, there's the concept known as respondeat superior, meaning YouTube bears liability. Its employees, unless they're doing something absolutely egregious and outside their line of work, they bear no personal responsibility whatsoever. And that's true, Alpha Fox Adam. But in this case, these John Doe's 1 through 20 are YouTube employees. And so let's say I work for Acme Corporation and I am a delivery driver. I'm delivering widgets from the factory to Walmart. And Walmart is counting on receiving that delivery before Black Friday so that they can sell all the widgets and make a lot of money. If, as the delivery driver, I'm caught in a snowstorm and I get the widgets to Walmart on Saturday, am I liable? No. Walmart has a breach of contract against Acme Corporation, but not against me. But let's say, as a delivery driver for Acme Corporation, I'm driving drunk and I'm doing a YouTube live stream and reading the comments as I'm driving. Let's keep it topical here. And I hit and kill someone. In that situation, the estate of the person I hit and killed would sue both Acme Corporation and me. So, unless YouTube's employees are the ones violating his copyright somehow, they bear no responsibility here whatsoever. And that's true, Causeless Rebel. There probably would be a force majeure clause in the contract, but it's just a simple hypothetical. So I mean, in this case, they're almost certainly going to be they're almost certainly employees. So the introduction. Since the filing of the first amended complaint, YouTube and unidentified individuals at YouTube have made determinations outside of the Digital Millennium Copyright Act, notice, and takedown system, giving up their safe harbor protection under the DMCA and causing plaintiff harm by interfering with his ability to exercise his copyright. Once again, he fundamentally misunderstands the DMCA. Just absolute fundamental misunderstanding. Defendants YouTube and individuals at YouTube, John Doe's 1 through 20, are severally liable for damages related to plaintiff's first amended complaint against remaining defendants. They're severally liable. I mean, for starters, no, they're not. And in here, I'd argue, if I were making this motion, I'd say they're jointly and severally liable. Because here it says, well, either one of them could be liable, but, maybe not both. You want to argue they're both liable and they're both individually liable. Jurisdiction and venue. This district has subject matter jurisdiction over this action pursuant to 28 U.S.C. 1331, that's federal question jurisdiction, and 28 U.S.C. 1338, jurisdiction over copyright actions. This district has personal jurisdiction over all defendants. Oh, Jesus Christ. My brain is going to break once again. This district has personal jurisdiction over all defendants under the criminal copyright activity predicate. No, it is never RICO. It's never RICO. It's never RICO. Do I sound like Emily D. Baker yet? Repeating myself? It's never RICO. RICO violations make up the majority of the factors in the claims in this action. It's never RICO. I already discussed in my last video why it's not RICO. It's good house reference there, Alpha Fox Adam. It's never Lupus, and it's never RICO. Basically, RICO is the lupus of the legal world. But in order for it to be RICO, it would have to be a criminal copyright violation. It's not a criminal copyright violation for the reasons I discussed in the last video. But let's pretend that Josh and Kate somehow did violate the copyright in a criminal fashion. YouTube didn't. YouTube was relying on the DMCA safe harbor. They're not in an enterprise with Josh and Kate in any fashion. This is dumb. This is D-U-M, dumb. Yes, I realize dumb has a B, but Delete Lawz is so dumb. He only deserves D-U-M, dumb. So there are a civilian can bring a RICO case, not criminal, but there are civil RICO causes of action. But basically, like I said, there has to be a RICO crime involved, and then you can sue for the damages caused by that RICO crime. But it's just dumb. And I agree, Alpha Fox Adam. So Iraq is something they teach you. It wasn't even taught in the first day of law school. It was taught in the first day of law school orientation. And Iraq stands for issue, rule, analysis, conclusion. They completely skip analysis. So it just doesn't work. And so DMCA, cheeky monkey, YouTube is not liable for copyright infringements as long as they comply with the DMCA. But Delete Lawz doesn't understand that, yeah, they've complied. But we'll get to that. So, pursuant to 18 U.S.C. 1965, the RICO, venue is proper in this court because it sits in a district that defendant Peter resides. And pursuant to 1965B, a court that is proper for one RICO defendant is proper for all other RICO defendants. The problem being, it's not RICO. It's never RICO. Delete Lawz will never, ever have a RICO case. I will regrow my leg before he gets a RICO case. That's not going to happen. He has not won yet. As Team Skeptic puts it, he's 0 for X plus 1. He will remain 0 for X plus 1. Parties. I, Jose DeCastro, am an individual residing at Santa Monica. Why put I? Put plaintiff Jose DeCastro resides here. Defendant Google LLC is a Delaware corporation doing business worldwide with their principal address at 901 Cherry Ave, San Bruno, California. I can only identify defendants, John Does 1 through 20, individuals at YouTube answering DMCA complaints by dispute number, a DMCA dispute tracking system at YouTube, and timestamps as they sign their emails anonymously as the YouTube team. That's because they're the YouTube team. They're Goosebump. You're missing out. I know you're from Utah, but not here anymore. As you undoubtedly remember, Mount Olympus is beautiful in snow, and we've had snow the last couple of days. You're missing out. Ski resorts are really snowy for this time of year. Don't tell anyone I said that, though. They'll get after me. Crowds are an issue. So, factual background. I have published over 800 videos to which I own the valid copyright to which I've owned to which I own the valid copyright to. There's at least one too many twos in that sentence. As content to my YouTube channel. Defendant YouTube publishers have copied my content without consent. They don't need your consent. And they haven't copied it. They have used it in a transformative way. They have reinterpreted it. Jesus. Defendant YouTube has specified their DMCA designated agent as Copyright Operations YouTube LLC. So why are you bringing Google LLC? YouTube LLC. YouTube LLC. YouTube LLC. There's a reason why. Okay, the reason, so Alphabet has subsidiaries, and some of those subsidiaries even have subsidiaries. And the reason they have subsidiaries with different LLCs is because if YouTube were successfully sued for something, they only want YouTube to be liable. They only want YouTube's bank accounts to be seized. They don't want Papa Google or Papa Alphabet's accounts to be seized. And as long as they're appropriately segregating, you're not going to be able to pierce the corporate veil and get at Google's assets or Alphabet's assets that are unique to them and not to YouTube. So upon receiving notices of copyright infringement to the agent at paragraph 11 by plaintiff under 17 USC 512C3, YouTube and John Doe's have failed to take down infringing content on their service. Now, we'll get to this, but there are no relevant copyright violations in this lawsuit. Not a single one. But sweet dreams, cheeky monkey. Thanks for hanging out. But he seems to think that the one video from Unclean Hands or the videos from Team Skeptic are somehow covered in this, but they're not. But we'll get to that. We've discussed it already in a previous video, but we'll get to it again. So YouTube and John Doe's 1 through 20 have determined on multiple occasions that content is exempt from takedown under DMCA due to copyright fair use, not even considering that I notified them that I had filed a court action. Once again, a fundamental misunderstanding of the law in violation of the DMCA and its standard technical measures. No, this is your fanfic technical measures. This is not the DMCA. I mean, I think that's his goal, but I mean, he thinks that from Kate and Josh he's going to get go away money, but his idea of go away money from them is some absurd amount. I mean, I'm not privy to his emails to them, but we've seen from his trolling of from Irish Demon trolling Delete Lawz, that his idea of going away money is like $50,000 up front and then a percent of revenue from their channel going forward. That's not going away money. That's absurd. And frankly, like I said, YouTube, he's not going to get go away money from them. It's going to be a real fast 12b6. So defendants, YouTube and John Doe's 1 through 20, do not accept notice of a filed court action to defeat a counter notice. That's because it's improper the way you're doing it. Under the standard DMCA under the DMCA standard technical measures, but instead require a court-stamped copy of the full lawsuit. Yeah, that's the standard. Because he's trying to say, look, I'm suing for copyright. So you've just got to take my word for it that this is the video in that lawsuit. They don't have to take your word. You've got to show that you're suing for that video. Defendants refuse to answer what they mean by court stamped, whether it's a received stamp, which isn't relevant to e-filed documents, which all federal courts use, or whether they mean a certified copy, both of which are more than the requirements of the DMCA standard technical measures. YouTube does not have a policy that is consistently enforced for the termination of repeat infringers under 17 U.S.C. 512. They do consistently enforce. I mean, they just don't give strikes for objectively frivolous copyright strikes. That's good news, Unclean Hands. Which of her 3 charges was it? She has so many arrests, I don't actually know. I really think with her it is a mental problem. Like she's batshit crazy. So my works are listed in Exhibit 1 of the First Amended Complaint, and ones added since the First Amended Complaint are listed in Exhibit 1 of this supplemental complaint by YouTube URL. Certificate of service and certificate. Yeah. So Exhibit 1. I'm sure there would be a whole lot more links than this if he hadn't spent 2 weeks suspended, I think. So let's go over this again. First off, there may actually be, I don't watch everyone's videos covering Delete Lawz. There's not enough time in the day. There just isn't. There may be some actual copyright infringements out there. I have not seen any from Kate, from Masshole Report. I don't watch Josh's channel, so I couldn't tell you. But I doubt I doubt he has any. I'm sure his videos are fair use. Unclean Hands, his one video a year ago, fair use. All of Team Skeptic's videos, all of Irish Demon's videos, fair use. All of Blue Bacon's videos, fair use. KFAR, fair use. But let's say they're not. That's where we get into the DMCA. So here's how the DMCA works. It is a safe harbor for the website, for YouTube. And a great big ow to you too, Detective. Good to see you. So the DMCA doesn't protect me. It protects YouTube. Because if I were to put a copyright violation on their website, on YouTube, and they did not follow fair use, then YouTube could get in trouble. I haven't seen Rights On's video, so I don't know if it's fair use or not. Here's the difference. So I like Blue Bacon. I like Blue Bacon. Lying to Kate and Shiz and Johnny O, that was a dick move. But that's between them. I don't expect content creators to be 100% honest with me. This whole parasocial relationship, just people get too invested in it. Blue Bacon is entertainment, and I find him very entertaining. So as long as he's not doing something illegal, like stolen valor, impersonating a cop, or something along those lines. If he lies for entertainment purposes, great. That's what movies are. That's what stories are. And he's a great storyteller. So as Dog Detective says, it's for them to work out themselves. I'm not a party to that. So as far as Blue Bacon copyright striking Rights On, people have said, well, he's no better than Delete Lawz and his false copyright strikes. The difference being, and once again, I'm not in Blue Bacon's head. Delete Lawz has filed over 200 copyright strikes. And they're frivolous. They're abjectly frivolous. He has no argument in support. But if Blue Bacon on one video legitimately thought, you know what, I don't think this one is fair use, that's what it's there for. So I can't get in his head and say, did he think it was fair use or not? So basically, once again, that's between him and Rights On. So basically, that's That's the best answer I can give as far as that goes. But so yeah, so with the DMCA, here's the process. I make a video criticizing Delete Lawz. He doesn't like it and thinks it's a copyright violation. So he files a copyright strike with YouTube under their video takedown copyright notification. And he says, hey, YouTube, I think this video is a copyright violation. YouTube takes the video down. Or in many of these situations, which he's whining about here, YouTube says, no, that's so clearly fair use that we're not even going to entertain it. And it ends on the first step. But let's say there could be a question. You do a counter notification. So I say, nuh-uh, this is fair use because of all these factors, which we discussed in a previous video. You know, I didn't use this whole video. I added commentary during the video. Stuff like that. So after that, YouTube says to Delete Lawz, all right, sue or shut up. And he seems to think that means he sues Kate and Josh, and that means no one can use any part of any of his videos ever again. And all he has to do is show YouTube, hey, look, I'm suing Josh and Kate. Therefore, Team Skeptic's video is also a copyright violation, and there can't be fair use on it, and therefore you have to take it down based on my lawsuit against Josh and Kate. Well, no. For starters, due process. Team Skeptic gets a chance to argue, hey, look, this is fair use. But number two, copyright violations are, for starters, not based on the video that you're alleged to have infringed on. So if Kate and Josh did violate Delete Lawz copyright on a certain video, that's not determinative of whether Team Skeptic's video using that same video is also a copyright violation. Because I know this is difficult for Delete Lawz to understand. They're different videos. You have to do an analysis on the allegedly infringing video, each allegedly infringing video, and you have to sue based on each allegedly infringing video in order for YouTube to run afoul of the DMCA. I mean, so if I were to give you legal advice on clean hands, I'd look into, you know, contacting them again and saying, hey, look, he hasn't sued me. You're violating my rights here. And I mean, frankly, it would be a waste of time, but you could sue him for, you know, loss of income due to that video. you won't get anything from him, but yeah. So he just has such a complete misunderstanding of how all this works. But he's got a 12-year-old moron in discussing laws, sitting on his shoulder saying, yeah, do this is how it works. But it's such a completely ridiculous misreading of the law that, like I said, it should take YouTube about 3 minutes. I mean, it helps that I'm sure they have a database full of motions. They have really good lawyers there at YouTube. But it'll take about 3 minutes to draft their 12b6 motion. Lego houses. It can only be Lego houses. And I mean, if there's a video where he says he owns 3 houses, I hope someone has that saved, because when Josh and Kate win, I have a feeling they're going to get lawyers' fees at a minimum, because this is going to be deemed frivolous. And his actions have run up costs. He said he aims to run up costs. Will they win their defamation actions against him? Maybe. And frankly, if they do, I don't know what the damages are, but my point is, when they win, they're going to have an evidentiary hearing where they say, tell us what all your assets are. And don't disperse any of these assets, because we're going to seize them. And if he has 1 house, they're not going to be able to seize 1 house, because it's his house. Generally, you're not going to be able to seize his personal residence. They might be able to get part of it, depending on what state it's in and the local laws. Bankruptcy laws, there's a homestead exemption. Some states, it's like $100,000 exemption. Florida, it's an unlimited exemption. So you're going to file bankruptcy, you buy a $20 million house before the clawback period, and they can't get at that $20 million house. But in some states, it's $100,000, so they can say, yeah, you can keep $100,000 worth of that house, but we're going to seize the rest of it. So the problem for him, though, is if he owns 3 houses, 2 of them are not covered by the homestead exemption, and they can be seized 100%. I don't buy that he has 3 houses, but I don't know. But so getting back to the title of the video, is Delete Lawz the dumbest quarter of a man on the planet? My answer is yes, probably, because he has stated, both in videos and in previous filings, he relies on his YouTube videos for his livelihood. They're how he makes money. So, what's the dumbest thing he could possibly do? That would probably be pissing off YouTube, because they're under no obligation to give him a platform. If you sue YouTube frivolously, are you going to get kicked off? I mean, so I haven't looked it up. So there are retaliation laws. So if I work for Walmart and they don't give me my paycheck one week, so I sue under employment law, and then they fire me for suing them. Well, that just means I get another lawsuit because they fired me as retaliation for suing them. Because federal and most state employment law gives protection. Or if I'm a whistleblower, let's say I work for Acme Corporation and they're dumping widgets into a river. And I go to the EPA and I say, hey, look at what Acme Corporation's doing. They can't fire me for that. That's retaliation. I'm probably not going to work there long because it's going to be unpleasant, but they can't fire me. Or even if I'm the CFO, Chief Financial Officer for Acme, or not even the CFO. If I'm a simple accounting clerk and I see accounting fraud going on and I go to the SEC and I say, hey, look, SEC, there's accounting fraud going on. Therefore, their security, their stock is mispriced, enriching the executives. Well, number one, I might get a great big payout from the SEC based on their whistleblower incentive programs. But also, Acme can't fire me because that's retaliation. YouTube is not his employer. So they don't have employment law. It's not there. I don't know that there's any protection from retaliation. I doubt YouTube kicks him off while they're a defendant. But as soon as they win, he's gone. So, I mean, and when I say I don't think they kick him off while while they're a defendant, if he continues breaking terms of service, they will regardless. Because, you know, they've got an easy claim if he tries suing them again for that. Look, we kicked him off in the ordinary course of business. He violated our terms of service, so we kicked him out. So that I just don't see them keeping him on. And number two, we discussed last week the Acer Thorn lawsuit. If you remember, Acer Thorn is a copyright lawsuit, but not a fair use or DMCA lawsuit, where Acer Thorn claimed his computer glitched and started a live stream without any input from him. Therefore, it was not copyrightable. But he copyright struck a whole bunch of people and sued them and sued YouTube, but then dismissed YouTube as an act of gamesmanship, realizing, hey, they're going to beat me, but I've got default judgments pending against these other defendants who didn't respond. And after YouTube was dismissed, they said, nah, and they intervened and they stepped in place of the defendants and fought the copyright and won. So there's precedent. Is YouTube going to step in for Josh and Kate here? Probably not. But if he pisses them off enough, there's precedent for it happening. So who knows? Unfortunately, my crystal ball is in the shop, so I can't see the future. But he's just setting himself up for... We've talked about Walmart a lot. He may find Walmart, working as an elderly greeter being his only option once this lawsuit's over. Because the Power Rangers don't want him back. YouTube is more than likely going to kick him off the platform. We've seen Rumble doesn't work for him. I mean, the dude even gets kicked off Twitter. In this environment, short of actually tweeting swastikas, as Kanye West does, how do you get kicked off of Twitter? Oh no. Oh no. Yep, Liz. That's what we just covered. But he just can't help himself from making bad decisions. Which, I mean, and it entertains me, at least reading and making fun of them, and then watching the videos where other people make fun of him. I don't watch his videos directly. I mean, it could be, but how's he going to make money on Truth Social? I mean, there's a lot of dumb people on there, but is it monetizable? So with that, I think I've discussed pretty much what I wanted to today. So looking forward, I'm not going to give you a date yet because frankly, I don't know when I'm going to get to it. There's a federal court lawsuit where I've only read the very beginning of a motion, but a sovereign citizen was suing in federal court and submitted a handwritten motion, and then apparently the judge bench slapped him with her order. So I'm going to read through that in a coming live stream. And I'm also going to so this will be a little bit more aimed at content creators, at fellow YouTubers. But I'm going to discuss sort of in generic terms, none of it will be actual legal advice, but sort of how to stay safe as a content creator. The steps that I haven't taken yet because, I'm a lawyer, therefore I give advice and don't take it. But by the time I'm monetized, I'm going to be looking at doing most of this. So how to keep yourself safe as a content creator. But then it will also, to those of you in chat, there will still be some information that I would hope would be helpful in general. So those are the two main things I'm looking at doing coming up. It very well could be William Graber. Like I said, I only looked at the very beginning. It was on Reddit, so I've got to go back and find it again. But it looked like it was going to be amusing. And Liz, thanks for the offer. It's I don't think I need help yet. I just need to get off my ass and do things. But sometimes energy is the commodity that just isn't there. So with that, I'm going to go and eat some dinner before the Pac-12 championship game. Go Utes. And thanks for joining me. Do all the YouTube-y things, like, subscribe, share, bribe your friends and family to do the same. And I will see you guys next time. And that could be what it was. Oh, and, I do have Discord. I do have an email. Frankly, I'm better at email than Discord. If there are videos you want me to cover, if want my reaction, go ahead and send them. So yeah. But with that, this time I'm really leaving. I'm not going to do a Delete Lawz and stay on for another hour after saying I'm leaving. So have a good night. Thanks for joining me. See you next time.